I would say that with respect to the business executives or the managers for clients, when I say managers, the artists have personal managers who take care of their day-to-day affairs and advise them. I will spend a fair amount of time with those managers before spending time with the artists. I will spend a lot of time with music industry executives, both senior officers and senior lawyers from the companies, talking about their problems, the issues, trying to come up with resolutions. A lot of what I do and my colleagues do also is in connection with negotiations. We often play a very behind-the-scenes role. We'll take a look at language that one side wants to put into a contract and advise the legal department of a record company, for example, how to respond to that request, what the legal implications are that might not be obvious to somebody who just focuses on contracts every day. So I spend a lot of time doing that. A lot of time reviewing and revising written submissions to the court, preparing for depositions. When there are going to be oral arguments, trials are rare, but if there's a trial, it's like you go into warrior mode where you are entirely focused for sometimes months intensely on preparation for a trial, to prepare for the case that's going to be presented and to prepare for all the unexpected things that you have to anticipate. So you have a lot of guesstimating as to what can go wrong, what the other side's positions are going to be, and the like, and you have to do a lot of preparation for that. And then when I do oral arguments for motions, asking a court to throw a case out or to grant a judgment to a client, that tends to be also a great deal of office preparation time. And same thing with appeals, which I didn't mention. But if you go to court, the losing side has the right to appeal to an appellate court to review the case and to decide whether the judgment should stand or not. So I get involved in those appeals. I also, from time to time, get involved in the writing of briefs that are called amicus briefs or friend of the court briefs. And those are submitted to appellate courts to supplement what the parties to the case have submitted to the court. For example, in the famous Grokster case, which was a case involving the Grokster online service that allowed people to use their computers to access music without paying for it and to download the music and exchange music. The music industry and the motion picture industry brought a lawsuit against Grokster to try to shut it down. When the case went on appeal to the U.S. Supreme Court, after the initial trial court said that Grokster has to be shut down, and then the appeals court, called the Circuit Court of Appeals, also said that the Grokster had to be shut down. Then the Supreme Court agreed to take the case because it had national importance. The Supreme Court will take cases that have overriding national importance. And this was a very important case in terms of interpreting the Copyright Act, and it would have great impact on creators and owners of intellectual property and those who want to distribute it without licenses. So the Supreme Court decided that they were going to address the issue. The Recording Academy asked me to do with my colleagues, to do 2 briefs in the U.S. Supreme Court representing the Recording Academy, and we had about 50 artists, including members of the Eagles and rap artists and just a broad range of members of the Dixie Chicks and so on, all of whom took the position that the record companies and music publishers were right in the Grokster case, and the Grokster should be shut down. So that friend of the court or amicus brief was something that we devoted a great deal of time and attention to. So my day is filled with that and with also schmoozing. what's going on today in the music industry. Right? There were rumors. It's a very small industry. How it will affect my clients. All of this I need to know. So there's a lot of time talking to people.